Thank you.
Ms. Collins?
May it please the Court. Susan Collins, I'm representing the juvenile, excuse me, Guthrie G. We're here this morning in the matter of Guthrie G, a 14-year-old young man subjected to a warrantless search of his home, as well as questioning by the police without the benefit of any guidance from an interested adult or parent. On the day in question, which was back in January of 2003, Guthrie G was home. He was by himself. 3 uniformed officers came to his door. It was cold outside. It was January. He let them in. He told them it was cold. Come on in. And they went inside to the kitchen. He was polite, respectful, and they indicated to him that they wanted to question him about a BB gun. And did he have one? And when he said that he had a BB gun, the officers then said, well, could you get it for us? He then started to walk towards his bedroom, and the officers accompanied him there. I would suggest that at the time the officers came into the kitchen, there were no exigent circumstances. They were not concerned. They did not search him.
Well, why aren't there exigent circumstances if they're concerned about there being a weapon around?
But the initial questioning's clear. Well, first by their actions, they didn't indicate that there was any concern. They didn't search him. There's nothing to indicate they searched the kitchen. They didn't pat him down.
But weren't their questions designed solely about the gun?
Actually, they asked him, yes, they did ask him, do you have a gun? And his reply was, yes, I have a BB gun.
And so they asked him about a gun, not a BB gun.
They did ask him about a gun. That's correct.
And where is it?
And where is it?
So that
it's in my bedroom.
indicates that that's their concern, is the gun.
Yes, absolutely. Once they determined it's in the bed, he tells them it's in his bedroom. They had every opportunity to sit down, wait for a search warrant. And
how do they know he's telling the truth? What if he's lying? He says it's in the bedroom, but it's not. It's out. He hid it in the bushes in the park a block away. How can they know that he's telling the truth until they go and look in the bedroom? Suppose they secure the house, as the dissent suggests in the appeals court. Secure the house and go and get a warrant. Ha-ha. But the gun's in the park, really, unbeknownst to the police, because the juvenile wasn't telling the truth. And somebody's picked it up and committed a murder in the meantime.
First of all, I would suggest the juvenile says he has a BB gun. He doesn't even say
okay,
he
but
has
again,
a gun.
They don't have to believe him. Not everybody who's questioned by the police, I suggest, in the police experience, tells them the truth.
That's absolutely true. He could have said, I don't have a gun at all.
Can we just go back a little bit? Hadn't the police received a report from the father of another child that there was a gun?
Actually, they had received conflicting reports. They had received reports from the father of the other child that there was a gun. They had
Not a
actually
BB gun.
questioned.
Not a BB gun.
That's correct.
Gun.
But they had also questioned the other juvenile who said it was a BB gun. So they did have conflicting information. The father said he saw him in his workshop. He thought it looked like a gun. Later, they did question the juvenile himself, and he said it was a BB gun, and it was over at Guthrie G's house.
Let me ask you this. If we should decide that there were an exigency, a public safety exception as set out in New York versus Quarles, then don't all the other cases within the house, what happened within the house, consent, et cetera, all go away, and we're only left with the question at the police station about the opportunity to confer with an interested adult?
Yes, I would suggest that that would be correct, but I would suggest that Quarles doesn't talk about in the house at all. Quarles only makes that public safety exception for public safety in the public arena.
But we don't know where the gun is.
That's correct. We don't, but we have information. We have information from the other juvenile who said it's at Guthrie's house. I just left there 5 minutes ago. That's where it was. The father had picked him up at Guthrie's house. Presumably, they hadn't gone, and that's the information the police had. They can speculate all the time. Yes, maybe he dropped it off. Maybe he did this. Maybe he did that. But the information they had was that it was at Guthrie's house. And when it was confirmed by Guthrie further by saying, yes, it's in my bedroom, now they have 3 individuals who are more or less indicating that it's in the house. So that's when it's time to stop. It's time to go get a warrant to do the search. This is a 14-year-old young man. I would suggest further that the 14-year-old young man doesn't have the authority to even set to a search. He's 14. He's, at the time...
Well, again, the consent issue goes away if we find that it were an exigency.
That's correct. But I would suggest that Quarles clearly does not go anywhere near the basis of allowing for the search to take place in a home. Homes are sacrosanct. That's been that you don't search a home. That's why we have the provision for warrants. And now that they had 3 individuals giving them the information that, in fact, the gun was, at the time, it was a BB gun, but that it was in the home, that there is no public safety exception under Quarles at that point. Now, excuse me, the information is confirmed it's in the home, and at that point, the officer should have received a warrant.
Well, in Commonwealth versus Allen A., a Mass Appeals Court decision, that was a gun in a home, and the trial judge there ruled that the public safety exception to Miranda set out in Quarles was applicable, and that was in a home.
I would suggest there's a couple of distinctions. One is the information they received that this young man in Allen A. actually had the gun on him, that it was a loaded handgun. And when they went in, clearly they went in with guns drawn. They placed him immediately on the floor. But even more importantly, he wasn't in his own home. He was in someone else's home, and the female who presumably lived in the home invited them in and said, he's over there, he's in the living room, kitchen, I don't know which room he was in. But clearly there was someone else, it was someone else's home. They gave them permission to come in, searched the individual, pointed him out. And again, the circumstances were such that the information they received that it was a handgun on his person. And clearly they acted as if they were under fear. Guns were drawn, they immediately placed them on the ground, they immediately searched them. The officers gave no indication that they were in any fear of this young man. Walked in the door, stood in the kitchen, no evidence that they even patted him down, searched him, even looked around the kitchen. There's nothing in the record that indicates that they did anything.
Well, there's a difference between, they're not in fear of him, they're concerned for the public safety should there be a gun loose out somewhere.
But all the information they had was that it was in the house. Nothing to indicate that it wasn't in the house. Whereas in Allen A., there was indication that this young man had walked around with it for a while, had actually left someone's house, walked through, and now happened to be located in someone else's home. So I think there's a pretty significant distinction between those two. So the Quarles would not extend in this circumstances.
I'm still confused here about the facts. The person who came to the police station and reported that his son and the defendant had a gun observed them not in the defendant's house, but in a tool shop.
Correct.
Connected to the other person's house. And when the father came in and saw that they had a gun, they took off with it. Right?
Yes.
So, I mean, we're really talking about a volatile situation where these 2 young children appear to have a gun and they have run away with it.
That's correct. And had the police arrived perhaps at that time, perhaps there would have been the more public safety exception would apply. But they didn't. In the meantime, they actually spoke with the other juvenile who said it's a BB gun. Actually, they spoke with the father again who said, I just picked him up. He was at Guthrie's house. And then they spoke with the juvenile who said, yes, it was a BB gun and it's at Guthrie's house. The police then come in, make their initial inquiry, and Guthrie says, it's in my bedroom. Now they have 3 pieces of information that this gun is in the house. So once they have established fairly certainly that it is in the house, that's when it's their obligation to go get a warrant. To act in any other manner would be to suggest that it's okay as long as we have some piece of information from somebody to, as long as it becomes too speculative. And I would suggest that that is not a sufficient basis to allow a warrantless search, that it has to be significantly more than that. So given that it is a warrantless search, and I would suggest that...
Excuse me, the
Yes.
facts as found by the motion judge weren't that the first boy, the informant's boy, say, didn't say that the gun was a BB gun. According to the facts found by the judge, he said that the boy said he believed the gun to be a BB gun.
Yes, that's correct. He believed it to be a BB. That's what they thought it was. They're 14 years old. I don't know what... There was nothing in the record to suggest what
Would you
evidence they
think it'd
had.
be different if it was a .357 Magnum instead of a BB gun? If the police were concerned about,
No, I don't. They've established it's in the home. It's in the boy's bedroom. They've established it by 3 different individuals, the father, the 2 boys.
Yeah, it turned out to be a .22 caliber Ruger.
It did. That's
So
right. So I don't think it makes a whole lot of a difference, other than the boy's belief that it was a BB gun. But beyond that, I mean, that may go to whether he's consenting, what he thinks he's consenting to, and all of that. But no, I don't think it makes any difference. Once they've established pretty clearly where this weapon is, they have an obligation to go get a warrant. This is someone's home. And to allow a warrantless search for no reason other than maybe it makes it easier to go get it, it just doesn't make sense. At that point, there were no public safety concerns. They knew where it was. They're sitting in the kitchen. The young man's making no move to run. He's not combative. He's not doing anything.
Well, they're not worried about the young man. They're worried about the gun.
But if the young man has possession of this gun, if it's under
No.
his control in some manner, I understand that, yes, it could be in the community. It could be. I mean, we could always speculate what could be, but they have information from three different people, that it's in the home.
But they also had information that after the boys had been working on the gun, they left one home and went to another home 4
That's
or 5
correct.
miles away.
Yes.
Giving ample opportunity to get rid of that gun.
Sure, they could have, but they had information after that it was in the home.
Ms.
Can I-
Collins, do you want to go on to the next part of the argument, that assuming, it's whether or not they could question him?
Yes, sure. The questioning at the police station?
Yeah.
Yes, Your Honor. Certainly at the police station, this is a situation, the mother was called. She apparently said she was going to come and then couldn't come. They took the young man down to the police station in the back of his cruiser. They get there. Only thing that's on the record is that Dad walks in. Clearly, I think the record indicated that they...
You left out one fact. They didn't question him. They waited for
Yes,
the
they
father
did.
to come.
That's correct. I don't dispute that. They did wait for the father to come. I'm not sure whether it's in the record or not that the parents were separated. It's not clear whether he lived with his father. But nevertheless, his father shows up. There's nothing in the record that they even said so much as hello to each other.
Surely-
It's simply, here's the Mirandas. Nothing in the record that indicates the father had any knowledge of what his son was charged with. It's simply, here's your Miranda rights. Do you sign them?
Right,
Okay,
does-
signed
does-
them and immediately started questioning the boy. Never were they given an opportunity to consult. Never were they told they had the opportunity to consult. Like I said, I'm not even sure that they even said hello to one another.
Well,
It was,
there's at least in the appeals court opinion, the footnote says Officer Lake also testified that he explained to the father why he was there. Is that incorrect?
he explained to the father why he was there, that we're talking to you. I'm guessing it was, actually, that's all he testified to. I don't know what he explained to him. The record is deficient as to other than I explained why we were there. He may have said, we're here because we found a gun in your son's bedroom. We're here because he ran away from home. We're here. I don't know what he said.
Well, why he wasn't there wasn't because he ran away from home. This wasn't the boy who ran away from home. This was the other boy.
But we don't know what Officer Lake actually said to him, other than he said
Other than he testified, he explained to the father why he was there.
But we don't know what that, I believe that was a one sentence in the, during the hearing. I explained to him why he was there. I don't know what that was that he explained. I'm here to question him
Wasn't-
regarding the
is-
potential for a crime. I'm here to charge him with a crime.
Well, we
They
haven't
already-
taken
why is
leave
it-
of our common sense.
Right.
He explained to him why he was there. He was there because he was about to be charged with possession of a weapon.
I'm not sure that it may have been that we want to question
Oh,
your
he's
son
gonna be
regarding
charged
the
with-
weapon.
What else was he going to be charged with?
Well, he was also charged, I believe, with larceny of a firearm or receiving stolen property. So it's not clear. It may have been we simply want to question him where he got it.
Was there any evidence that the father and the son were alone together at any point?
No evidence at all that they were ever alone, at all. The evidence was that the officer came in, they signed the forms, and they immediately questioned the child. They didn't even ask the father, may we question your child? It was simply, do you understand your rights? Yes. Now tell me where you found the
It
gun.
seemed to me that that was the import of our holding in Commonwealth against Philip, which deals with whether you have to have the opportunity to consult as opposed to the actual consulting, because in that case there was evidence that there had been some time when the parent, I think it was the mother in that case, was with the child, and the court was essentially saying we can't ask that the Commonwealth prove what the mother said to the son, but as long as there was an opportunity to consult, not call your mother and your mother can't get here, but there was a real opportunity. I take it that that's what we were establishing.
Yes, I would agree, Your Honor. There's nothing in the record that indicates that there was any time frame at all, there was any offer, I will leave the room, I'll let you guys talk. Do you want to talk to your son? Nothing. It was simply, do you understand? You're here, here's your form, you've signed it. Do you understand? Yes. Okay, now, son, what did you do? Not son, but, young man, what did you do today? Where did you find this gun? I think was the first question. Where did you get it?
But we have never imposed a requirement that the juvenile and adult be informed that they may confer in private.
That's correct. I don't disagree with that, but there wasn't even an opportunity. There was nothing. It was simply, do you understand your rights? Yes. And the rights don't say anything about an opportunity to consult, that you can talk to your son. It was simply, you understand, where did you find the gun? It wasn't even, may I ask your son some questions? It was immediately into the questioning of, where'd you get this gun? So I would suggest there was absolutely no opportunity to consult. The officers didn't even hesitate. They didn't pause. They didn't even let the young man, like I said, there's nothing in the record that they even said hello to one another. I think they'd been sitting there quite some time, and they were anxious to move this investigation along.
Thank you, Ms. Collins.
Thank you.
Ms. Burbine?
May it please the Court, Carolyn Burbine for the Commonwealth. There was clearly a the public safety exception does apply here. The police were faced with a juvenile who fled with a gun that had been modified in an unknown and likely unsafe fashion. There was a parent who was so concerned about what he had seen his son and this juvenile doing that he reported them to the police. He said they were working on a gun in my workshop, and they ran away when I approached. They ran 4 to 5 miles to this to the juvenile's house, and even after I found my son and we started driving home, he jumped out of the car and ran off again. So that contrary to the defendant's claim, the police had absolutely no reason to believe these juveniles that this was just a BB gun. You have a concerned parent, concerned enough to call the police. The judge found it was a gun, that they said it was a gun. And so there was absolutely a volatile situation. And I would also state, while Quarles was to deal with a gun in a public area, a supermarket, LNA clearly states that the presence of a loaded gun in a private residence can represent a substantial threat. And also, these boys did run 4 or 5 miles, so they could have discarded it along the way. So the police had absolutely no reason to believe this juvenile, given his evasive behavior before they got to the house. And also, this gun was potentially modified, so they have no idea what these kids did to it. And indeed, they had cut the stock and turned it into a pistol grip. So I would posit
But
that
you don't mean to suggest that whenever the police think that there's a gun in the house, they can simply search the house?
No, you have to
public
have a
safety?
situation such as this where you have, this quickly occurring need to find this gun, and this clearly falls within the LNA analysis. Did the court have any more questions on that issue? No questions? Then I'll go on to the Miranda warnings. It appears to me that the judge made decided that they didn't have a meaningful opportunity to consult because, at least in part, because the officer didn't tell them that they had a right to a private consultation. That's in her findings. But what we have here is there was no questioning until after the father arrived at the police station, and this was done after they'd had the boy call his mother and tell her that the police were taking him down for questioning, and she in turn called the father because she could not come herself. He could get there quicker. So, and once he got there, the officer brought him to see his son, and he told them why they were at the station, and he read the Miranda rights, and the father acknowledged them in writing. So this whole procedure of waiting and advising them of the rights.
Was there any evidence that the father had consulted with the son outside the presence of the police officer?
No.
Surely a meaningful opportunity to consult, is that you in fact can consult. In other words, it's not simply, the case law isn't simply can the father, without even talking to the son. I can think of many circumstances where a parent might simply ignore what the son wants or think it's irrelevant to consult. It's not, our case law isn't that the parent can in all circumstances step into the shoes. The question is, does the child have a meaningful opportunity to consult? And I have to say, on this record, I don't see that there was any opportunity to consult. Whether that turns into an affirmative obligation of the police to say that you have a right to do that is a separate question, but the cases are either you have to show that there was actual consultation, or where we have said opportunity, depending on how you look at this child's age, it's where, the parent comes, they go off to one side, and then the police say, well, here, your Miranda, do you... It's not, the inquiry is not did the father explain the Miranda rights. The question is, did the father have an opportunity to consult with the juvenile, with the child?
And I would say that had they asked the police for, if they had just started talking in front of the police officer, that would have been their opportunity to consult, or they could have asked the police officer to leave so that they could consult privately. The fact that they didn't do so
But
doesn't mean...
I'm a little concerned because the police are anxious to get going, let's assume, and they've been waiting, and the father arrives, and the father has to ascertain, the father has received a telephone call from the mother. The father has to ascertain, what's happened. So the father may well have spoken first to the police, but there seems to me to be, there's no evidence that there was any consultation or opportunity to consult with the child.
Well, I think that by giving them the Miranda warnings, there's a, as the appeals court said, this is the time for reflection. There's a reason why they're giving us all this information. It's because it's important that I, as the father, am
But
here.
that's going to the father, or it's going
And the
to
child would understand that, too, because he would be there waiting for his father, and he would know that they weren't questioning him for a reason. They could be questioning him right now. Why am I sitting here waiting for my father? They must want my father here for a reason. And look, now they read the Miranda to both of us. They ask both of us if we understand it. And this is the time for reflection when they would sit there and say, well, there's a reason for this. And
may
that
I
is
ask
so
you a
that we
question?
can talk and decide.
Is it your position that the parent should have asked for some privacy to talk with his son?
No, I think he could. My take on this, especially where our cases specifically say the police don't have to say, you can talk about this in private, and they don't have to say, you have a right to consult before you agree to this. I think as long as they follow all of the provisions.
Well, how's a
where-
parent to get an opportunity to counsel their child, the meaningful opportunity to consult?
They can either start talking right in front of the police officer, or they can ask for privacy. And there is a case that says if they ask for a private consultation, the police officer doesn't give it to them, then there's a problem.
I mean, you look at Commonwealth versus Phillip, the language in Commonwealth versus Phillip seems clear. It says, at least with regard to juveniles over the age of 14, this court, unlike other states, has said that police officers are not required to give a juvenile and an interested adult an unsolicited opportunity to confer in private. Isn't that the end of the story?
That's correct, and I think that's the precedent, and that's valid, because I think the whole process invites the thought process on the part of the parent and the child. This is a serious situation. They're asking us to waive these rights, and it would prompt them to say, officer, we need to talk about this before we make this decision. Can we have some privacy? And then if an officer refuses, then I would say that's not valid. But there was nothing from either of these parties to indicate that they wanted to talk about it and were deprived of that opportunity. And I would also state that the boy testified that the Miranda rights were read to him. He understood what the police were saying. His father understood the Miranda rights as well. So he doesn't make a claim of, I didn't know that I could ask my father questions. I didn't know why my father was there. None of that is present here. And I also see no indication in this record that the police were rushing them.
I take it
in
the
any
meaningful
way.
opportunity, I mean, we've held in other contexts that a meaningful opportunity is not simply offering to call a parent and then the juvenile saying, no, I don't want to talk to my parents. Here, they actually ensured that the parent was there and was physically with the juvenile.
That's correct. They did not do anything until he arrived.
And would that be the same if he was 13 instead of 14?
13, they have to have the actual opportunity to consult, I
So
believe.
they
The
have
cutoff
to
age is
have
14.
the actual opportunity.
Well,
But
what
that's
do you mean
under
by that?
14, this boy was over.
Well, they have the opportunity here, too. You're saying there's
Well,
a
I think-
difference
I think-
in having the opportunity? Are you saying
I
under
can't
14 they
remember,
have to
actually.
actually have consulted?
I don't
in
remember,
private?
Your Honor. I'm not sure.
Well, Philip S. uses the words that in that case, the juvenile and his mother had the required actual opportunity, and that was under 14, whatever that means, the required actual opportunity. But let me ask you this question, Ms. Burbine. Do the judge's findings in any way bind us so that we can't rule in your favor?
I believe she found that even though the juvenile was questioned in his father's presence, they did not receive a meaningful opportunity to consult. And then she just said, I'm suppressing the statements. And then she also did find that because Officer Lake didn't advise them they had a right to private consult, that she also found that he did not advise them that they had a right to private consultation. So I think a lot of her decision-making was based on the lack of any advice from the officer that they could consult in private. I think that was a large factor in her decision, and I would posit that that was erroneous, or that it's not required. Does the court have any further questions? Thank you.
Thank you, Ms. Burbine.